In this podcast, we're still talking about acceptance. We're talking about it under a slightly different context, which is the postal acceptance rule. A few things to recall. For a contract to be formed, the offeree must communicate acceptance to the offeror or someone authorized by the offeror to receive it. What this does is create consensus ad idem, which is a meeting of the minds, and the offeror must show a willingness to be bound on the proposed contract terms, and the offeree must show a willingness to be bound on the same contract terms. And the offeree does this through communication of acceptance. Now, this brings us to the rule, which is no contract is created before the communication of acceptance, which means there are no obligations incurred before acceptance. We've discussed a number of surrounding issues. We've discussed the different ways to communicate acceptance, usually verbally or in writing, but it could be by silence if objectively that silence could constitute acquiescence. It could also be by performance, even though courts will presume a bilateral contract. Now, there is also the point that the requirement of communication may be waived. Only the offeror is entitled to waive the requirement. Waiver is determined objectively, and waiver can be express or implied. So, for example, in the carbolic smoke ball, the offeror did not require that Ms. Carlisle tell them that she was using the smoke ball. So they waived that requirement implicitly. Also recall that the offeror is the master of the offer, meaning the offeror gets to stipulate the mode of acceptance. Acceptance is effective usually only in the stipulated mode. There are some exceptions. Technically, another mode may be accepted if the offeror is not prejudiced by the non-compliance with the specified mode of acceptance. So non-conformity is acceptable if through a route no less advantageous to the offeror. If there is no mode stipulated, then any reasonable mode is permissible. Now that brings us to the first case we're going to talk about, which is just an illustration of the above principles. This is Eliason and Henshaw, which uses some very old language. Defendant in error means the appellant, the plaintiff, and the seller. The plaintiff in error refers to the respondent, who is also the defendant and buyer. The in error is an archaic term meaning in an appeal, and it's the prevailing party in the court below. So the facts are that the buyer offered to purchase flour from the seller. The buyer was at a place called Harper's Ferry, or near it, and the seller was at Mill Creek. Now, the buyer sent a letter by wagon to the seller on February 10th, offering to buy flour from the seller. Quote, "Please write by return of wagon whether you accept our offer." The wagoner works for the seller, and the letter was received by the seller on February 14th. The seller sent a letter back to the buyer dated February 15th, but the seller sent the letter to Georgetown, the buyer's place of work, not to Harper's Ferry, from where the buyer's letter had been sent. This letter left Mill Creek on February 19th by regular mail, not by wagon. The buyer wrote back to the seller on February 25th from Georgetown, acknowledging receipt of the seller's letter, but saying that since they hadn't heard from the seller when they had expected, which was the next day by wagon, they'd ordered flour from somewhere else. But the wagoner, with whom the buyer had sent their first letter, had said he's not returning to Harper's Ferry. Meanwhile, the seller had sent the flour to Georgetown, and the buyer refused to accept it. And the issue was, must the offeree communicate exactly as directed by the offer? The ratio says the offeror has the right to dictate terms upon which the offer would be accepted, and generally, unless the terms are complied with, the offeror is not bound. The reasons were, the buyer had asked for the letter to be sent back by wagon, because he could estimate when the wagon would arrive back. On that note, the manner in which a reply is made is generally unimportant, provided it was sent to Harper's Ferry and was not delayed beyond the time a wagon would have taken to make the journey. What this means is the precise mode of acceptance is irrelevant, but that mode had been stated to calculate the time. So the precise place of acceptance is also it is relevant, and the buyer is entitled to specify the place. Therefore, the mode of acceptance was not complied with, and no contract had been concluded by the parties. In this case, if the wagon had not been used, but the letter had been returned to the specified place the next day, that would have been acceptance of the offer. So again, it is irrelevant that the precise mode of acceptance is used as long as the time frame is complied with. The court is not going to have an absolute rule saying that if the mode is not complied with, then the acceptance is invalid. And here we see the court looking at the mode of acceptance only to denote a certain time expectation. So it's not a matter of communicating the acceptance by telegram, but that it must be communicated within the time a letter by wagon would have arrived. We know the general rule about acceptance. It must be communicated to the offeror. But we're going to talk about acceptance in a different mode now. And the reason is because if the parties are not face to face, they're not at a place where they can communicate immediately with each other, then problems can arise, because in that case, the parties are going to be communicated by correspondence. Here it's when parties are far apart, they might be in different jurisdictions, and the oral acceptance that would otherwise suffice is impossible. So there will be inevitable delays in communicating acceptance to the offeror and the corresponding risks that arise if communications go astray. So what if the parties are communicating from different jurisdictions? I live in Manitoba, the offeree lives in New Brunswick. What if acceptance is lost? I mail my letter of acceptance and a check to my insurer in Alberta, and the letter is lost by mail, my business is destroyed by fire. Do I have insurance coverage? This separation of parties by distance and the possibility that acceptance can be made sometime after the offer has been made means there are risks created, and those risks have to be allocated between the parties. Before we had the development of electric and electronic modes of communication, mail was the principal method of communication by which offer and acceptance were communicated to the parties. Now, electronic communication is basically instantaneous, so spatial separation doesn't matter. But what instantaneous communication does is create special risks if parties are in different time zones. If we have a physical and temporal separation between the parties, of course there is the risk that if the offer reaches the offeree, the acceptance may not reach the offeror. And the risks created by these situations force the law to allocate the risk of loss on the parties. The risk is on the offeror if the law will hold the contract to be made before the offeror gets the notice of acceptance. The risk is on the offeree if no contract results because notice of the acceptance never reaches the offeror. And this is how we derive the postal rule. This is why we need a special rule, because special situations are created when the parties are not face to face, such that the general rule for acceptance to an offer cannot apply. The general rule, as we know, is that a contract is formed upon the offeror receiving acceptance from the offeree. The offeror has to receive acceptance to know the offer has been accepted. Until then, there are no obligations. This is easy with instant communications, where there's little or no delay. So if you're face to face with somebody, or even you're at a distance, you're on the phone, or there's a fax. So here, if the communication fails, no contract is formed. There is no hardship on the offeree. But we have a problem when it comes to communicating through mail. Mail is non-instantaneous communication. It involves a delay, potentially substantial, between the offeree's transmission and the offeror's receipt. The problems are things could be delayed, things could be lost, or the offeror can decide to revoke the offer before the next communication happens. What that does is it creates an exception to the general rule, and that exception is called the postal rule, which is an acceptance by mail is effective upon posting, meaning acceptance is effective when and where the offeree sends it. So what does this mean? Well, for loss in the mail, the rule means the contract can be formed even if the acceptance becomes lost in the mail. The effect here is it prefers the offeree's interest. It is the offeror, not the offeree, who is expected to know the communication has gone astray and should break silence by inquiry. What does it mean for revocation of an offer? So what if the offeror attempts to revoke the offer after the offeree has dispatched the message of acceptance? Well, if we rely on the postal rule, acceptance is effective upon mailing, then the rule again protects the offeree. Meaning an offeree receiving an offer and mailing acceptance may rely at once on a concluded contract. He may at once go into market and purchase goods to fulfill the contract. What does it mean for overtaking communications? So when a rejection is mailed and it's followed by acceptance, and the acceptance arrives first, then the effect is given to the acceptance. When the rejection arrives first, it is unfair to bind the offeror to acceptance. So for example, offeree receives an offer. Offeree mails acceptance. Then, after that, the offeree sends a rejection of that acceptance during the time his letter of acceptance is arriving. Should this be allowed? Well, it shouldn't. The offeree should not be entitled to have the benefit of the postal rule in those circumstances because it allows speculation at the offeror's expense. If this was allowed, the offeree would mail the letter of acceptance, which binds the offeror when it is mailed, which is the postal rule. Then the offeree could say, watch the market during that period that the acceptance is in the post and wait to see if that contract is favorable. And if the contract is not favorable, the offeree would be free to revoke that acceptance during the time required for the letter to arrive. Cases therefore indicate that the contract is irreversible if there's acceptance, and neither party is bound until the acceptance. Why do we have the postal rule? It's inconsistent with general contract principles. It appears to be inconsistent with the idea that contracts are agreements made when there is communication of acceptance between the parties. The postal rule contemplates an agreement being formed prior to one of the parties having communicated to the other his willingness to enter into the agreement. Why do we say that acceptance is effective upon being sent? So why have we chosen that rule for the postal rule as opposed to acceptance being effective upon it being received? Well, many reasons have been put forward. None of them are particularly satisfactory, but there are several. An arbitrary choice was necessary is one. The second is the offeror, as the master of the offer, could have precluded the use of mail, so it's reasonable to impose the risk of loss associated with the use of mail on the offeror. The offeror will be aware when no acceptance arrives, so it's appropriate to place the burden on the offeror. And it would be inconvenient to have acceptance effective only upon receipt. The offeree could not assume a contract had been entered into until the arrival of acceptance had been confirmed. So all of these are reasons that are put forward for the postal rule. Again, none of them are particularly satisfactory. Essentially, we just need a presumptive rule which goes one way or the other.